students, I welcome you to yet another lecture on corporate law. The topic for today's lecture is alteration of share capital. In today's lecture, we shall try and understand the various ways in which the share capital of the company can be altered. We shall also discuss the reduction of share capital in detail. We shall also discuss further issue of share capital by the company. Under Section 61, Clause 1 of the Companies Act 2013, a company limited by shares or guarantee and having a share capital may alter its share capital subject to the fulfillment of two conditions. These are: number one, there must be power to alter the share capital in the articles. However, if the articles contain no power to this effect, the articles must be amended by a special resolution before the power to alter the capital clause can be exercised by the company. Number two, a resolution needs to be passed by the company. Dear students, we shall now discuss the modes of alteration of share capital. Alteration of share capital can take place in a number of ways. These are: number one, a company may increase the authorized share capital by such amount as it thinks expedient. Number two, it may consolidate and divide all or any of its existing shares into a larger denomination than any of its existing shares. For example, by consolidating 10 shares of rupees 50 each into one share of rupees 500 each. Number three, it may convert all or any of its fully paid up shares into stock or vice versa. Number four, it may subdivide its existing shares or any of them into smaller denomination than that fixed by its memorandum. However, the existing proportion between the paid up and the unpaid amount must be maintained. For example, the value of one share is rupees 100 each. Rupees 50 is paid up, and if it is subdivided into 10 shares of rupees 10 each, rupees 5 per share is the paid up share capital. A company may also reduce its share capital. And lastly, it may increase the share capital. Dear students, we shall now discuss reduction of share capital. A reduction of share capital is unlawful except when it is sanctioned by the National Company Law Tribunal. The share capital of the company is the only security that the creditors rely on. Any reduction of this share capital diminishes the fund out of which they are to be paid, and hence the power to reduce share capital is closely guarded. In Indian National Press Indore Limited, the court observed that the need for reducing capital may arise in various circumstances. For example, trading losses, heavy capital expenses, and assets of reduced or doubtful value. As a result, the original capital may either have become lost. Section 66 of the Companies Act 2013 provides the situations when the share capital may be reduced and also provides the procedure for reduction of share capital. Under Section 66, a company limited by shares or limited by guarantee and having share capital may reduce the share capital by passing a special resolution. Number two, by applying to the National Company Law Tribunal for reduction of share capital. It is only upon the approval by the National Company Law Tribunal that a scheme of reduction of share capital can be confirmed. A company limited by shares or limited by guarantee and having a share capital may reduce the share capital by A. Extinguishing or reducing the liability on any of its shares in respect of the share capital not paid up. For example, if the shares are of a face value of rupees 1000 each, of which rupees 500 has been paid, the company may reduce them to rupees 500 fully paid up shares and thus relieve the shareholders from the liability on the uncalled capital of rupees 500 per share. B. Either with or without extinguishing or reducing liability on any of its shares. Number 1. Cancel any paid up share capital which is lost or is unrepresented by available assets. An example would be the shares of a face value of rupees 1000 each fully paid up is represented by rupees 750 worth of assets. In such a case, reduction of share capital may be effected by cancelling rupees 250 per share. Number 2. Pay off any paid up share capital which is in excess of the wants of the company. For example, shares of face value of rupees 500 each fully paid up can be reduced to a face value of rupees 300 each by paying back rupees 200 per share. The proviso to section 66 clause 1 states that the reduction of share capital shall not be made if the company is in arrears in the repayment of any deposits accepted by it or the interest payable on it. Dear students, we shall now understand the procedure for the application to the National Company Law Tribunal. On receiving the application for reduction of share capital from a company, the tribunal shall give notice of the application made to it to number 1, the central government, number 2, to the registrar, number 3, to the Securities and Exchange Board in case of listed companies, and number 4, the creditors of the company. The National Company Law Tribunal shall take into consideration the representations received by it from the central government, the registrar, the Securities and Exchange Board and the creditors within a period of 3 months from the date of receipt of the notice. Proviso to section 66 clause 2 states that if no representation has been received from the central government or the registrar or the SEBI or the creditors within the period of 3 months, it shall be presumed that they have no objection to the reduction of share capital. Dear students, we shall now try and understand the duties of the National Company Law Tribunal. On hearing an application by a company to reduce its share capital, the National Company Law Tribunal must ensure that the reduction of capital is fair and equitable. In other words, the National Company Law Tribunal shall consider certain aspects while sanctioning the reduction. These aspects are: the interests of the creditors are safeguarded, the interests of the shareholders are protected, and lastly, the public interest is taken care of. In British and American Trustee Corporation versus Cooper, it was observed that in exercising its discretion, the court shall consider, while sanctioning the reduction, number 1, the interest of the creditors, number 2, the interest of the shareholders, and number 3, the interest of the public. Dear students, we shall now study the protection of the interest of creditors. Where the proposed reduction of share capital involves either denomination of liability with respect to the unpaid share capital or the payment to any shareholder of any paid up share capital, or in any other case if the tribunal so directs, the creditors are entitled to object. However, only the creditors who are having a debt or a claim which is admissible in the winding up are entitled to object. To enable them to do so, the tribunal will settle a list of creditors entitled to object. A creditor may consent to the proposed reduction. In case he objects, the tribunal may dispense with his consent, where it is of the opinion that his interest is secure. Thus, the tribunal will not sanction the scheme of reduction of share capital unless it is satisfied that every creditor of the company has either consented to the said reduction or their debt or claim has been secured or discharged. Publication of the tribunal's order. The order of confirmation of the reduction of share capital by the tribunal shall be published by the company in such manner as the tribunal may direct. Delivery of a copy of the order of tribunal to the registrar of companies. The company shall deliver a certified copy of the order of the tribunal showing A. the amount of share capital, B. the number of shares into which it is to be divided, C. the amount of each share, and D. the amount, if any, at the date of registration deemed to have been paid on each share. This information has to be provided to the registrar within a period of 30 days of the receipt of the copy of the order, who shall register the same and issue a certificate to that effect. The accounting treatment proposed by the company for reduction of share capital should be in conformity with the accounting standards specified in section 133 or in any other provision of the Companies Act, and a certificate to that effect by the company's auditor has to be filed with the National Company Law Tribunal. Dear students, we shall now understand the interest of the shareholders. The duty of the National Company Law Tribunal is to look after the interest of the shareholders. The proposed scheme of reduction must be fair and reasonable between all the classes of the shareholders in the company. If the capital of the company consists of only one class of shares and all of them are to bear the reduction proportionately, the scheme is obviously fair and must be confirmed. In Marwari Stores Limited versus Gauri Shankar Goenka, the defendant company had a capital of rupees 1,92,000, which was divided into 1,920 shares of rupees 100 each. By a special resolution, the company resolved to reduce the share capital to half. In other words, the paid up share capital was to be cancelled to the extent of rupees 50 on each share. The petitioner, a shareholder, opposed the reduction on the ground that there had been no loss of capital and therefore the reduction was unwarranted. The court here held that it is not necessary that the scheme of reduction will only be conferred on the proof of the fact that there had been a real loss of capital, but on the fact that the company seeking the reduction has duly passed a resolution to that effect. In Sandvik Asia Limited versus Bharat Kumar Padamsi, the court held that once it is established that non-promoter shareholders are being paid for the value of their shares and an overwhelming majority of them have voted in favor of resolution for the reduction of share capital, the court will not be justified in withholding the sanction to the resolution. In Cosmos Steel Private Limited versus Jairam Das Gupta, the court held that when a direction for purchase of shares is given by the court under section 402 of the Companies Act 1956, that is, power of the Company Law Board on application for prevention of oppression and mismanagement, and consequent reduction in share capital is to be effected, the procedure for reduction of share capital need not be followed. In Re Sai Limited, it was held that reduction of the share capital of a company is a domestic concern of the company and the decision of the majority would prevail. If the majority by a special resolution decide to reduce the share capital of the company, it has the right to decide to reduce the share capital of the company, and it has the right to decide how this reduction should be effected. Dear students, we shall now understand the further issue of share capital. Companies issue additional shares for various reasons. One of the primary reasons they issue additional shares is to raise new capital to fund existing new business operations. The principles governing further issue of share capital are governed by Section 62 of the Companies Act 2013. It provides that where at any time a company having a share capital proposes to increase its subscribed capital by the issue of further shares, such shares shall be offered, number 1, to persons who at the date of the offer are holders of equity shares of the company. The point to remember is the shares shall be offered to the existing shareholders in proportion as nearly as circumstances admit to the paid up share capital on those shares. This is known as shareholders' preemptive right. The Supreme Court in the landmark case of Nandlal Zaved versus Bombay Life Assurance Company Limited laid down that the company must give the first option to the existing shareholders before favoring anyone else. The Companies Act 1956 and the Companies Act 2013 also explicitly provide for a preemptive right of the shareholders to the new shares of the company. In this case, the appellants contended that the directors' exercise of discretion in issuing further shares was mala fide in nature as it was done to gain control of the company. The court, while dealing with this contention, held that since the directors exercised their discretion in a bona fide manner for the best interests of the company, mere incidental benefits to the directors would not warrant interference in the further issue of share capital. The Supreme Court also, in the case of Sahara India Real Estate Corporation versus SEBI, held that Section 81 of the Companies Act 1956 postulates a preemptive right on the part of the existing shareholders to the new issue of shares. Thus, it is evident that a company which engages in further issue of shares should offer it to its existing shareholders before favoring anyone else. The third point to remember is that the offer shall be made by notice which shall specify the number of shares offered. The fourth point to remember is a time limit of not less than 15 days and not exceeding 30 days should be provided to either accept or to decline the offer. Number 5. The notice should also mention that if there is no response to the offer, it shall be deemed to have been declined. Number 6. The notice should also provide that the person to whom the offer is made shall have the right to renounce the shares offered to him or any of them in favor of any other person. Number 7. After the expiry of the time specified in the notice or on receipt of earlier intimation from the person to whom such notice is given that he declines to accept the shares offered, the board of directors may dispose of them in such a manner which is not disadvantageous to the shareholders and the company. Dear students, we shall now discuss further issue of shares to employees. Section 62, Clause 1, Subclause B provides that a company may issue further shares to its employees under a scheme of employee stock option. Employee stock option has been defined under subsection 37 of Section 2 of the Companies Act 2013, according to which it means the option given to the directors, officers or employees of a company or a holding company or a subsidiary company which gives them a benefit or a right to purchase or to subscribe for the shares of the company at a future date at a predetermined price. Dear students, we shall now discuss when the restrictions with regard to further issue of share capital provided in section 62 shall not apply. The restrictions provided in section 62 shall not apply to the increase of the subscribed capital of a company caused by the exercise of an option as a term attached to the debentures issued or loan raised by the company to convert such debenture or loans into shares in the company, provided that the terms of issue of such debentures or loan containing such an option have been approved before the issue of such debentures or the raising of a loan by a special resolution passed by the company in its general meeting. Where any debentures have been issued or a loan has been obtained from any government by a company, and if that government considers it necessary in the public interest to do so, it may by order direct that such debentures or loans or any part of it shall be converted into shares in the company on such terms and conditions as appear to the government to be reasonable in the circumstances of the case, even if the terms of the issue of such debentures or the raising of such loans do not include a term for providing for such an option for such conversion. However, if the terms and conditions of such conversion are not acceptable to the company, it may within 60 days from the date of communication of such order appeal to the National Company Law Tribunal, which shall, after hearing the company and the government, pass such an order as it deems fit. In determining the terms and conditions of conversion, the government shall have due regard to the financial position of the company, the terms of issue of the debentures or loans as the case may be, the rate of interest payable on such debentures or loans, and such other matters as it may consider necessary. Where the government has, by an order, directed that any debenture or loan or any part thereof shall be converted into shares in a company, and where no appeal has been preferred to the National Company Law Tribunal, or where such an appeal has been dismissed, the memorandum of such a company shall, where such order has the effect of increasing the authorized share capital of the company, stand altered, and the authorized share capital of such company shall stand increased by an amount equal to the amount of the value of the shares which such debentures or loans or part thereof has been converted into. Dear students, this is all with regard to today's lecture on alteration of share capital. In today's lecture, we try to understand the various ways in which the share capital of a company can be altered. We also discussed in detail the reduction of share capital and the further issue of share capital. Hope you have been able to enjoy the lesson and understand it fully. Thank you and stay blessed.